Good afternoon. You are in the right place for today's MSHA mid-year review webinar. So thank you again for joining us today. This is the fourth webinar in the 2020 MSHA webinar series, and it will be discussing a review in mid-year of the Mine Safety and Health Administration's enforcement and guidance and regulations, as well as some cases of note from the Federal Mine Safety and Health Review Commission. My name is Nick Scala. If you have joined us before, you probably recognize my voice, and I want to welcome you back and thank you for joining us. For those who are new, welcome as well. I am the chair of the National MSHA Practice Group for Carey. I represent companies in the mining industry in relatively all aspects of dealing with the Federal Mine Safety and Health Review Commission and the Mine Safety and Health Administration, whether that is doing normal contest of citations or advising in development of policies, safety and health, or managing investigations into agents of management, serious injury or fatality situations, or those that are related to interference or discrimination claims by miners. I spent my life before becoming a lawyer working in the mining and construction industry, and I'm a certified mine safety professional. So welcome you guys today. We're going to have a discussion that covers a range of topics, and I think that we couldn't do a mid-year review of what's going on with MSHA without looking at their response to COVID-19 in the workplace. So that is where we're going to start. And after that, we're going to look at what is happening with the One MSHA initiative and the reorganization of the agency's enforcement resources, also the management of those resources, what is coming down the pike in the spring rulemaking efforts. And now this is an important one. We've seen a lot of items be tabled or described as proposed or described as of interest the last few years. But one thing to keep in mind, and one reason why we will probably see a couple proposed rules be released in the next few months, is that we are in an election year. And this administration, who knows what's going to happen in November. We're not going to try and predict the future in this presentation today, but we do know that when there is a possibility that there could be a change in administration, the outgoing or the current administration likes to try and get a couple rules, or at least one rule, out and in a more formal stance. We saw that at the end of the Obama administration with the really late hour push through of what is now the metal non-metal workplace examination rule. So we'll look at a couple areas where we might see some rulemaking efforts by this administration, just in the event that they may not return. Obviously, we know it's possible that this administration very well could return, as they're not going through or ending their second term. And then lastly, we're going to look at some legal decisions of interest. And, a bit disclaimer on this one, we're going to focus on a number of cases that have to do with 105C of the Mine Act, which is discrimination and specifically interference is what we're going to look at today. And that is namely because there has not been a lot of recent decisions coming out since COVID-19 has largely shut down decisions in cases coming from the Federal Mine Safety and Health Review Commission and its judges. There have been a few trickling out, but for the most part, we have not been having hearings. Now there is a push for some of those hearings to go into a virtual setting, and I think we probably will see that become more the norm as we continue through the pandemic. But as for now, we're going to look at a couple cases that are of interest and might have some impact on your operations. So first and foremost, what is MSHA doing in response to COVID-19? If you have been paying attention to the agency throughout this process, which I'm sure most of you have been, you'll notice that there has not been a great deal of material published by MSHA, especially if you are also in the position that you monitor what OSHA is doing. OSHA has put out a great deal of guidance, a great deal of materials regarding what they are going to do in terms of enforcement and the areas in that regard. MSHA has been much more conservative in what they have published. They have discussed COVID-19 and the response to it on both of their most recent quarterly stakeholder calls, but the MSHA resource page for COVID-19 response is relatively limited in what it contains. Now, what it does contain, though, is a sentence that I have up here because I thought it was important in orange, and it says, MSHA will continue to perform its essential functions, including mandatory inspections, serious accident investigations, and investigations of hazard complaints. You know, for the most part, that is MSHA's functions from a regulatory or an enforcement stance, and they have continued to do that. Now, there were some changes, and we're starting to see that it get back to a bit normal, but we did see MSHA slow. They did offer some guidance and specifics to areas where they might offer some relief in terms of training obligations, but, you know, more or less, they have continued to conduct their inspections. And I think that you're going to see that continue to ramp up as we move to the back half of the summer now. Because MSHA, of course, you guys know, they have their twos and their fours, as we call them, where there's mandatory inspections. And they're going to have to make sure they get those completed by the end of the year. MSHA has the past few years, and for a relatively long time at this point, completed 100% of their inspections. And I expect that they intend to continue that trend. Some other areas that, though, we're seeing, you know, a bit of pressure on the agency, and I say a bit because it's not a great deal, but there has been legislation proposed by Senator Manchin of West Virginia and several other senators. It has not been voted on. It has not been finalized in any way, but legislation has been introduced, and it's called the COVID-19 Mine Worker Protection Act. If that were to pass, it would require MSHA to take immediate action and within 30 days promulgate an emergency temporary standard, which would be related to COVID-19 and offer them something enforceable to issue citations for if operators are not complying with it. Right now, they obviously do not have an infectious disease standard, nor does OSHA. There's pressure on both agencies to do that. It's not only from a legislative point of view, but also from the legal. The United Mine Workers and the Steel Workers recently brought action against MSHA in the Court of Appeals for the District of Columbia, trying to get them to force MSHA to instill an emergency temporary standard. That actually was just denied in the last few days, an unpublished decision that is pretty brief in that it just simply reaffirms that there's a great deal of deference offered to the agencies, in this case MSHA, to determine whether or not it is necessary to put an emergency temporary standard in place. So the DC Circuit did not grant the UMWA's request. They can continue to petition MSHA independently, and there is an opportunity, if there is facts that change which show a spike in cases transmitting in the mining industry, that they could once again bring that action in the court. But the DC Circuit did not decide to force MSHA to put in an emergency temporary standard, which is similar to what they did previously when an industry and labor organization tried to sue OSHA to do the same. So we aren't seeing those work, but they are nonetheless, these legal challenges brought by labor exist. And I think, you know, depending how the next few months go, we might see renewed vigor in similar legal filings. What MSHA has done is they've recommended everybody follow CDC guidance. And just recently, in the last few weeks, they have put out a number of pamphlets or infographics, whatever you want to call them, partnered with the CDC regarding their recommendations for COVID-19 protections in the mining industry. And again, largely these follow what we know to be existing guidance. There is the one that I have a screen capture up there on the screen right now, which is the COVID-19 and mining. There's also another one that is for minors with serious or underlying medical conditions, and largely those conditions are the same that would make an individual high risk even if they weren't in the mining industry. So do you have COPD or asthma or other chronic lung diseases? Do you have immunosuppressant symptoms or a disease in that case, or serious heart conditions, or if you're 65 or older? Those are, again, things that we should have been seeing throughout this process as high risk factors. Additionally, you're going to see that MSHA, or maybe you won't see it, but they have been broadcasting in their stakeholder cards, they are requesting, but not requiring, that the industry submit voluntarily information of COVID-19 positive cases that have been contracted or are present in the mining industry. Now, again, this isn't a requirement that you have to do it, but what MSHA is trying to do is track the information of the presence of COVID-19 in the mine working environment. And why would they want to do that? Well, one, part of it is for their allocation of inspection resources. If you're having a cluster or a breakout in an operation, they're obviously going to reconsider whether or not they send their miners to those areas, their inspectors. But also, part of this decision by the DC Circuit to not require MSHA to put out an emergency temporary standard is based off of MSHA's defense of what they have done. And what they have done is offer this guidance and cite to other regulations which they can potentially use to enforce protections for COVID. But it also looks at what is the risk to the industry. So if MSHA has information about the number of cases and that is relatively accurate, that will allow them to better defend their position if needed to if needed to be defended. Additionally, we have seen that MSHA has put a temporary stay on some obligations during the pendency of COVID-19, and really the timeline is the presidential emergency declaration. So while that is in effect, MSHA is recognizing that you might not be able to perform annual refresher training, or you may not be able to have certified persons recertified in certain areas. And these are some specific examples that MSHA has denoted on their COVID resource page. So annual refresher training for Part 46 and Part 48. What has also been listed is CPR and first aid training. They've also relaxed what is required for annual fit testing on respirators, because that can be a destructive test and obviously supplies are limited. They are granting temporary stays on these types of orders, not forgiveness for 2020, okay? Now, I think we're going to have to wait and see, because that might play out the longer that the temporary or the presidential emergency order remains in place. But for now, MSHA is not committing to saying you don't have to perform these during the year, and that might be because you are avoiding having large groups in a room for training, or because vendors are not able to come out and travel to your site and perform the training and perform the certification. But, you know, if you are going to be avoiding some of these, you know, some best practices that we want to try and put in place is at least document that we've had them planned, and that as a result of COVID-19, we cannot have them take place. And again, you know, just for the sake of having an easy visual, we're going to use annual refresher training for this. So if we have our annual refresher training due by the end of July every year, but our training partner can't come in, or we don't want to have our training take place because of concerns with having our miners in a relatively small area, and we cannot accommodate for virtual training, or we cannot accommodate for social distancing while doing that training. We want to create some kind of record which can at least serve to say that we have thought about this, we have looked at the other options, those are not feasible for reasons A, B, or C. And as such, we are going to continue to evaluate the situation and see when we can. We don't have a hard deadline that these have to be done right now. Okay, we will have until that emergency declaration is ended. And then from there, MSHA said that they're going to give people a reasonable amount of time, and that they will give you that reasonable amount of time. It won't be a hard deadline, but it's going to be something that you need to be in communication with your district personnel, letting them know that you are scheduling, and this was the earliest date that you could schedule, or things of that nature. Again, that's why we want to have maybe this log of what we've been trying to do, because it's going to help us really create what is, you know, our good faith attempts to get the training and comply with the standards. And we could not, because of hardships or challenges presented by COVID-19. Now, OSHA, again, you'll hear me say this probably more than once, more than several times throughout this presentation, they have released more guidance on this. They have released specific guidance which talks about establishing that good faith attempts to meet requirements or meet deadlines. And some of the things they include in there are what we just talked about, best practices. So do you have communications with your trainer or with the company coming to do certifications or whatever it may be? And you are looking at when they can get back out here. Are you setting tentative dates, even if they have to continue to be rescheduled? Those are things that we want to be able to monitor, and we want to be able to prove that we were making these attempts if and when it's ever challenged that we were outside of the compliance deadline. Additionally, if you're getting citations for this, you want to challenge them, and you want to really, you can probably do it through the informal process if you reach out to your district to request a 10-day conference or an informal conference, and just simply outline that you could not comply with whatever regulation you're cited for due to challenges with COVID-19. MSHA is working with, and I think they will continue to be willing to work with the industry as long as there is good faith attempts to meet compliance. So that is something to keep in mind. Also, I want to be very clear here, and MSHA has said this on several occasions, and it bears repeating, that this stay on training obligations, it is not complete. It is not extend to all types of training. You cannot have untrained new miners on your site. Additionally, you cannot be sending people out there without having their task training completed or the necessary task training completed. You need to try and find ways to do that, whether it is doing small groups where you can social distance or requiring the use of PPE in order to make it safe. Whatever it is, you do have to still have those initial training requirements met. There's no temporary stay on those. There's no forgiveness if you don't have those. So some areas where you want to look, and that takes us to this next page as well. So, you know, I mentioned on here, where could we possibly see enforcement from MSHA? I've mentioned the failures to do your training, so Part 46, and that's really going to look at new miner, newly hired experienced miner, task training. Those are important areas where you're not going to get any leeway. Also, depending on your operation and depending on the size of your operation, I know that working during COVID is nothing new for the mining industry. From the get-go, and almost immediately in all states, the mining industry was considered essential business, meaning that it could continue operations. Some operations, depending on the size or how busy they are, there were shutdowns, or if there were individuals getting sick. Now, I think companies as a whole are starting to get a better feel of what they can and cannot do and how to put in COVID-19 exposure and response protocols. And if not, you know, I think it bears mentioning that we do highly recommend that you have a comprehensive exposure and control response plan for COVID-19 at each of your workplaces. And we're not going to get into discussing those a great deal today because we have different topics, but if that's something that you're interested in and you have questions, then, you know, I encourage you to reach out to me or look on the Con-Maciel Carey blogs, either the MSHA Defense Report, the OSHA Defense Report, or the Labor and Employment Defense Report, because we are cross-posting all of our blogs that have to do with COVID-19 response, just so everyone's getting the information that's out there. But part of this, from a mining perspective, means to be you need to maintain that you have a failure to notify MSHA of your operational status. Now, we talked about earlier, they want you to voluntarily provide those updates if you are getting cases at your line, but there is an obligation to notify them if you're going to shut down for any point of time or if you're going to restart. And that's an easy one where we can see, you know, we forget to do it because of COVID-19, and then the citation can be issued. So we want to make sure that we're monitoring that. Some of the operations that I see that would be more an issue is when we have maybe portable mines or portable plants where they may have been shut down for some time because only a few people work there, as opposed to more of a fixed location. So you want to make sure that you're looking at that. Again, we haven't seen a lot of enforcement due to COVID-19, but these are areas where we see the opportunity for it should the agency take a more aggressive stance. But workplace examinations, MSHA has described this as being one area where they could issue citations because you have the obligation to examine for any hazards that may adversely impact the health and safety of the workplace. So are you taking proper protocols in terms of cleaning? Are you increasing that frequency? Also with 5657-15006, that is specifically looking at PPE and clothing for hazards and irritants in the workplace. Again, another area where we could be looking at potential enforcement as a result of COVID-19. And then lastly, look at your Part 47, so your HAZCOM plans, right? There's been a lot of supply chain issues. There have been people buying more cleaning products or different cleaning products than you ever possibly had acquired before. Make sure that we're getting all the appropriate hazard communication information and we're providing training if there is any new requirements. MSHA does not have the same obligation on operators to do a hazard assessment or PPE hazard assessment that you have to document, but nonetheless, if we are bringing new chemicals or new substances on our work site, we do have the obligation, one, to update our plans, two, to provide our miners with appropriate PPE to use that safely, and to make sure they have the training to appropriately or to use the necessary PPE safely to protect themselves. So some low-hanging fruit that, you know, I would recommend everyone take a look at, make sure that we're on par and we are making sure that those don't fall by the wayside while we still scramble to protect the workforce and figure out what is going to be our compliance requirements. Because again, this is an evolving situation. You know, we are seeing spikes in many states around the country, which is really bringing questions about, will the reopening plans continue unabated, or will we see more limited or widespread shutdown? So, you know, how that might affect the mining industry, again, I don't think anytime soon they're not going to be considered part of the essential infrastructure or essential business group, but there may be more focus on said operations if we do continue to see these spikes in cases. Last thing we'll talk about quickly on COVID-19 is reporting. With MSHA, again, we talked about there is not an express requirement for you to notify the agency if you do have any positive cases on site, but they are requesting that voluntary information. And again, there's, you know, everyone can determine whether or not they want to do that. In terms of 7001, though, so your injury and illness records, if there is a case of COVID on site, MSHA does not consider this to be work-related, okay? They are giving companies kind of the pass that, not the pass, but they are not considering it work-related unless it can be very clearly established that it was contracted at the site. And in that case, you may have to file a 7001 form, but it's not necessarily every case of COVID-19 at your facility or at your workplace is going to be considered work-related. And as we talked about, OSHA gives us a bit more guidance with that. So they have taken a relatively similar stance to MSHA in that if someone contracts COVID-19 and they're a member of your workforce, more than likely it is not due to an exposure at the workplace. OSHA, and again, we're looking at this because we don't have this level of detail from MSHA. This is from OSHA. Employers are not required to undertake extensive medical inquiries. Again, there's concerns there with what may happen in terms of privacy, but they do recommend that you ask some really base level questions. Ask the employee how they believe they got it. Is there someone that they interact with or they spend time with? Maybe it's a family member, or out of work activities where they could have had COVID-19. Additionally, you're going to want to look at, have you been on the other cases at your work site? Were those individuals working closely? Were they sharing tools? If you want to be especially safe, you want to try and really drill down on what they were doing, how frequently they were doing it, who they were doing their task with. Do any of those other persons have symptoms, or have they come down with a positive case? These are important questions that you want to ask because, again, while it's not going to be work-related every time, and the agency doesn't consider it to be work-related every time, you again want to try and do some of your background information and cross your T's and dot your I's. Additionally, it's good to think about what tools or equipment is being reused by multiple persons, maybe on one shift or even on multiple shifts. And if there are a number of people using the same equipment, do we disinfect it in between shifts or between persons entering it? These are probably best practices. Are we going to be cleaning tools that might be used between shifts or between multiple persons? We want to make sure that these are being followed because this will help us with that work-related list question if any cases do arise. So with that, we'll look at some more traditional issues or the topics that we would discuss on this webinar. And we do this one each year just trying to kind of give everyone the opportunity to take stock of where we're at. So we've talked about it for the past few years as it was discussed as going to happen and as it was eventually rolled out, but there has been a pretty significant reorganization of MSHA. And you can see it on the website from the fact that we no longer have a distinguishing between coal and metal, non-metal fatalities. They're all just being considered mining fatalities. But in the field, we've also seen this blurring take place. And, this is an image of a slide that MSHA has put out, and sometimes it's best to get it straight from the horse's mouth, but the blurring is the distinction between coal and metal, non-metal enforcement. They touted this as being quite a bit or directed to help the agency operate more efficiently, to reduce travel times, to use the closest field office to inspect the closest mines. Total, there were 213 mines that were blurred, meaning they were coal mines that now have metal, non-metal inspectors at them, or they were metal, non-metal mines that are now being inspected by coal mine inspectors. Now that is most certainly the more prevalent of the two, that you have former coal inspectors or even active coal inspectors inspecting metal, non-metal mines. There were a lot of these mines were kind of in the Appalachian or the Ohio River Valley area, as that is where there's quite a bit of coal mines, and there have been quite a bit of coal mines shut down. So it was a reallocation to help the efficiency of the agency in terms of travel time, but also to help with what has been a struggle for the agency to reallocate inspector resources around areas where mining environment or the mining contingency of operations has decreased significantly for one side or the other. In addition to that, they also created a new regional hierarchy. Typically, MSHA had the administrator for enforcement the last few years, who was over coal and metal, non-metal. Typically, it used to be a coal administrator for enforcement and a metal, non-metal administrator for enforcement. It was then combined into one administrator for enforcement, who's Tim Watkins. He had a metal, non-metal admin and a coal admin. Now that has changed, and there is the Administrator of Enforcement and then 3 regions across the country, and there is a regional administrator in each one of those. So what we have now is a Western district, a Central district, and an Eastern district. Obviously, from a geographical standpoint, they are not equal. What they are equal by is the number of minors in each district, or each region, I should say, which is why, if you're looking at the screen, you can see this strange carve-out where the Central region has almost all of Kentucky, and then down through Tennessee, North Carolina, and Georgia. It doesn't make a lot of sense, given how close they are to Birmingham, that their region is based out of Dallas, or how close they are to Beaver, where the East region will be headquartered. But that is because they were trying to have the same number of minors in each region. Brian Geppert is going to be in charge of the Western region, Dave Weaver, the Central. Right now, the East, they are looking for the permanent fixture to be the Eastern regional manager, but right now it is Scott Manville. So a bit of a different hierarchy. You still have the same district offices working. They just have a new level above the districts in between headquarters and them. So you now have these regional offices, which are going to be situated in Dallas, Vacaville, and as I mentioned, Beckley or Beaver, West Virginia, where the Mine Academy is. So a bit of a change in what has happened. MSHA has said that they are not going to be blurring any more mines in the near future. They're going to leave it at this 213 operations. But probably one of the more, or I should say, more felt and less broadcast changes has been on the contest or litigation side. Typically, MSHA has for a number of years used their conference litigation representatives, or CLRs, to hear most cases, or at least most non-serious cases, from the stance of 104Ds and things along that line, for contest and for trying to settle some of those cases before they get the solicitor's office involved. Typically, you dealt with a CLR from your district. So if you were in the North Central District, you dealt with a North Central District CLR. Same with the West or the South Central or the Northeast. What we have been seeing is that, you know, a metal, non-metal mine might be sent to a coal CLR to discuss settlement. And, you know, that has been interesting in some ways because, you know, there is kind of the expertise that you've been dealing with metal, non-metal citations and working to conference them and settle them. And now you're doing that on the side of, or a coal inspector or former coal CLR is trying to settle those. And so that, you know, has been difficult in some stance, not in others. It often depends on who is going to be the approving manager. At first, you had a lot of coal managers then going to approve these settlements for metal, non-metal mines that were discussed with coal CLRs. Now we're seeing kind of a shift where those coal CLRs are going back to the appropriate district manager. So they're working through that, but nonetheless, there's just a pretty consistent shifting of resources around MSHA to try and fill the plates of all the individuals. I see one question asking who the names were for each of the regional managers. So Brian Geppert is going to be the manager of the Western region, David Weaver, the manager of the Central region, and then the acting regional manager for the East is Scott Mandeville. And he is the acting, and they are still looking for a permanent position. He might very well be the permanent manager, but MSHA has posted the opening nonetheless. So otherwise, what is going on in the enforcement? So we're at that point of the year where we can get access to the 2019 data. We can see that there were roughly 13,000 mines in the country, and of those 11,800, give or take a couple mines, were metal non-metal. So quite a slant in terms of the total number of mines to the metal non-metal industry. The operators or the employment is around 330,000. That is a roughly 3/4 metal non-metal by the last data I saw. Last year, MSHA did almost or over 38,000, so almost 40,000 inspections, and issued 99,000 citations with about $50 million in penalties. So they certainly have been a little less in the total amount of penalties assessed. And just remember, this is for both metal, non-metal, and coal. In the past, MSHA did this data broken down by the different sectors. And we used to see really a trend where there was many more citations, or a fair amount more citations issued in metal, non-metal, but the price or the total millions assessed was usually more slanted in the coal, where a higher price per penalty or price per citation. So we are obviously still seeing inspections. They are completing their 2s and 4s, and 100,000 citations last year is, obviously no dramatic downtick in enforcement. But for a normal year, or I should say, comparing back to the last decade or so, 51 million is a slight decline in the total dollars assessed. I will also say that it hasn't been really broadcast that much, but MSHA continues to do their impact inspections, or at least they did up until March, when COVID-19 started to shut everything down. So that's just something that we didn't hear a lot about when we were in the Obama administration. The results of the impact inspections were broadcast monthly. They're not nearly broadcast as more, but nonetheless, they still are occurring, or were occurring up until there was some drop in inspections. So it's just something to keep in mind. This is determined by your inspection history, how many SNSs you're getting, how many citations you've been getting compared to other mines in your specific area or your specific breakdown of the industry, so what you're making or what you're extracting. Also, it's going to look at if you've had fatalities or serious injuries or a pattern of either of the two. You might be subject to these impact inspections, and what those typically are multiple inspectors showing up and really doing a deep dive on your facility. It's one of those situations that we always talk about that you want to be prepared for, having multiple persons trained on accompanying MSHA when they get on site, because the impact inspection or a multi-inspector inspection of some sort is that situation where you need to have more individuals prepared to go out there. I see one question that comes back again to these regional managers. It was, what have the regional managers been doing since the blur, and what do we expect them to be doing moving forward? They are really going to be similar to the roles that the administrator for metal non-metal enforcement and the administrator for coal enforcement did before, which is manage those districts under them. And so in this case, we're not going to have the regional managers only handling metal, non-metal, or coal. They're going to be kind of this next line hierarchy for all the district managers in the area. They're also going to be involved in terms of, probably dealing with the enforcement that comes down, or the response to serious accidents or to serious injuries or fatalities or emergency situations. They will most likely also be kind of one of those persons that can interact with the mining industry, possibly when we start having conferences again at those, and can be a resource for operators to reach out to. I think that is the intent of them, but essentially it moved two individuals who are located in Washington, D.C. at the headquarters, who were over metal, non-metal, and coal, and it gave them a specific region of the country where they were over both metal, non-metal, and coal operations. And so they are just going to be another line of management above the district managers and give the district managers a bit of senior MSHA management closer to where they're physically located as opposed to being on the East Coast in Washington, D.C. I think that was the intent behind it. Especially with the blur, they wanted to have these resources closer to home so that any issues could be addressed in a closer geographic proximity to the mines where they might be happening. So that is really what they're intended to do. I guess we're just going to have to wait and see what we see them doing moving forward, since it is a relatively new position and new role. But your main point of contact is still going to be your district manager for your operation and your field office supervisors. This is just going to be another level of management above them before you get to the assistant secretary and his executive staff in Washington, D.C. So what is happening on the regulatory agenda? So where are we seeing rulemaking efforts coming by MSHA? The two to take note on, and that we expect to see some movement in the remaining months of 2020 are the proposed rule for residual crystalline silica or quartz, and the written safety program for surface mobile equipment, including powered haulage equipment. Now, the silica regulation has been talked about since the end days of the Obama administration at MSHA, when OSHA came out with their own new updated silica regulation. We expect to see something coming out from this around August, and it will likely be an update to the existing rule, which is based off of recommended exposure levels from 1973, to give some further modification and a reduction as what is a permissible exposure level. So just a bit of a simplification of it, but really what we have with MSHA is that the exposure limit is roughly 100 micrograms per cubic meter. The current PEL, or permissible exposure level for OSHA under their new regulation, is half of that, or 50 micrograms per meter cubed. Additionally, OSHA has an action level that is again 1/2 of that a permissible exposure level of 25 micrograms per meter cubed, which trigger quite a few obligations by the employer. We don't know what is going to come down in this regulation exactly. We typically anticipated it was going to follow what OSHA had put out, or in some way, shape, or form follow that. I will say that MSHA has been questioned on this many times, both from labor organizations and politically. Why does OSHA have a regulation that is 1/2 of the exposure level, or roughly? Again, the calculations don't line up identically, that of OSHA. So, you know, we're going to have to wait and see what comes out, and we expect that to come out, though, by the end of the year. And that will put the proposed rulemaking process in place in the event there is a change in administration, and if there isn't, it will continue to move forward into 2021. We can look at, you know, the possibility that there would be something similar to what we see in OSHA's construction standard on silica, which looks at having this table of, it's called Table 1, and if you perform tasks listed in Table 1 as they're described and listed in Table 1, you may not be subject to the regulation. So there will likely be some push on the front of industry to get something similar put in there, or some kind of protections that might give greater clarity as to what we're seeing in terms of the regulation. I would expect whatever comes down will be legally challenged, which could delay it going into effect. Additionally, whatever this rule looks like when it is proposed, if there is a change in administration, it could be brought back into the rulemaking or proposal phase and changed dramatically. So we're going to have to wait and see what that comes to look like, and we're going to have to wait and see what happens in November with the election to really get a better idea of what this crystalline silica standard or this court standard is going to look like when it finally gets made final, which could be years away. Additionally, we have seen, though, and it's tied directly to this, that in the last few years, MSHA has dramatically increased the number of health samples that it has been taking at mine sites across the country. And that is both at coal and at metal, non-metal. So we have seen an increase in the amount of respirable quartz because MSHA technically has a respirable quartz standard at this point in time, not silica, although they are relatively interchangeable in terms of being used in the rulemaking and regulatory perspectives. So expect to continue that trend where MSHA is taking a great deal of samples. If you do have MSHA taking samples on site, all I would say is I recommend that you also take samples, especially if you're in an area where you know your operation has an issue with exposure to crystalline silica. Specifically, this was hard hit in the North Central District and the South Central District, where there's a lot of frac sand mines. If you are in those areas, I would recommend that you, every time MSHA takes a sample, take your own companion sample, which you are permitted to do, because if there is ever a citation issued for an overage based on MSHA sample, and you have data from that same shift that shows that the exposure was under, that is the basis for a legal challenge. If you don't have that information, you're going to be hard pressed to challenge that citation. So just be aware of that and be mindful that the testing is going to continue, I would say throughout this administration, no matter how long it goes. And if there is a change in administration, I expect respirable crystalline silica to continue to be an area of emphasis and an area where rulemaking could still happen. Powered haulage safety initiatives are also what I flagged, and we've heard about these for a while. As we can see, if you're looking through the actions that have taken place, there's been stakeholder meetings on this through 2018. We expect a rule sometime in July, so we haven't seen that yet, but we expect one to come out somewhere around here, maybe in the relatively near future. But this is going to require that each operation put together its own written plan on powered haulage. So MSHA, when they do powered haulage, they're looking at 3 distinct areas. They are looking at mobile equipment, they are looking at belt conveyors, and they are looking at seatbelt safety. The Assistant Secretary has talked throughout his term of the importance of getting people to wear seatbelts. Also, he has talked many times about the importance of having proximity detection on mobile equipment and surface operations. So, those are areas where we could see some potential regulation. What is going to be required in this haulage safety initiative? Again, it could be those. It could also be for belt conveyors specifically, requiring that the lockout tagout procedures be more detailed, be more specific to the equipment. Again, more akin to what OSHA does, as opposed to having just one broad lockout tagout policy. This might be something where you have to have a specific policy for each type of equipment. So again, one where we expect to see something relatively soon, and this would likely be focused on metal, non-metal surface operations. And that was, again, due to a number of fatalities, really, which were just collisions of mobile equipment back in 2018. There were several of them that took place all at once. And in 2019, there was a emphasis program by MSHA on powered haulage safety. So, this has been an area of focus. And as we get later in the administration's first term, we're starting to see them push harder on what they want to be their regulatory kind of priorities, just preparing for if they're reelected or trying to have that already in writing and promulgated in their proposed phase in the event that they are not. So with that, I know we're getting close to the end here, but I'm going to try and go quickly because there is some information that we should look at. There's been kind of this growing list of cases that had been discussing interference. And I know I mentioned that that is part of Section 105C of the Mine Act, which is discrimination and interference. And discrimination is different in the minor sense because it's a miner has done some sort of protected activity, which might have been talking to MSHA or complaining to MSHA about safety and health. The operator has taken an adverse action against that employee, be it, terminating them, demoting them, changing their shift to the night shift or something like that. And then there is an adverse action it was directly related to that. So that is what we're looking at when we have discrimination. When we're looking at interference, we're looking at something has been done to prevent the miner to exercise a protected activity. So, they were in some way intimidated or made to believe they could not talk to MSHA is typically, an example of what we would see here. It does not right now expressly require intent or motive to prevent the protected activity by the employer. So it is a very low bar, and it's a relatively ambiguous bar. And it looks at the totality of circumstances as a result of the actions by the employer. So not just is there intent or is there motive, but what has taken place? What did the miner do? What did the employer do? And right now there's two tests out there. And that is really why this is something that we want to talk about. So there's the first test, and this is the kind of more broad of the two tests. It's called the Franks and Hoy test. And it looks at whether or not a person's actions can be reasonably viewed from the members of the protected class, so that's minors, as tending to interfere with the exercise of protected rights. So that again is a relatively low bar. And so you want to look at that compared to what is the Pepin test. And this takes in the second bullet, and where the actions of the employer were motivated to interfere with the exercise of protected rights. So these two tests have both been proposed by administrative law judges from the Federal Mine Safety and Health Review Commission. And the reason that this is something that we've been monitoring is because there is not a test that has been accepted over the other one. There has not been a test that's been established by the Commission, or as you'll see in a minute, by the Federal Circuit Court as the test that all the judges have to implement and use. And industry has been trying to get that somewhat codified, or at least decided, so that they know what has to be applied in each situation. So, there was an attempt in this case called Marshall County Stone, where it was a petition was submitted to the U.S. Court of Appeals for D.C. It was a decision that was decided by the Commission, and that petition review was denied. And the question or the issue was, did a mine operator interfere with the miner's rights by requiring that all anonymous safety complaints also filed to MSHA also be filed with the company? The ALJ and the Commission found this to be interference because it sought to keep miners from submitting, or at least this is the way it was interpreted, submitting safety complaints to MSHA because they would also have to submit those to the operation, and therefore they would lose that anonymity. That's at least the way it was reviewed. So one where we did not see that. In another one, in Great House, which was another case, and it was voluntarily dismissed after we got another decision, but it was an application of the Franks and Hoy test. And it was not struck down, and it was not confirmed by the Commission or the higher court. And that's because it was a split decision by the Commission. And that means that at that point in time, there was an even number of commissioners, so we could not reach a consensus. So this test that was applied by an ALJ was made a final order. And that had to do with whether or not production and safety bonus programs were considered interference, and it was considered to be that by the ALJ. So a relatively broad area of cases and topics that were getting drug into this. In this case, McNary, it was actually found that there wasn't a case of interference, and that was using, again, that Franks and Hoy test, that more broad test. And this one was where a miner's rep in mine management had a disagreement during an emergency response at a mine site, and the miner's rep claimed that the actions of the manager interfered with his protected rights, or interfered and therefore prevented him from exercising his rights. In both cases, when it was when it went to the ALJ and when it went to the commission, they were denied and found that there was not interference. And the big takeaway from that was that a person's actions can be reasonably viewed from the perspective of the members of the protected class. Again, so you're looking at were other miners thinking they would have been interfered with in that situation, and that's really what it came down to. In this situation, others would not have seen what this individual saw as interference as that. And then this last case, which is Justice versus Rockwell Mining, it's interesting because we don't have that guidance that there is a specific test that has to be followed. We don't have that, unfortunately. And so in this case, the judge applied both the Pepin and the Franks and Hoy test to it. And that was so that they could be in a position that if it was appealed by the miner, because this judge found that there was no interference or discrimination, that there would not be a case where they could say you applied the wrong test because this judge used both tests. So an interesting case. In this one in particular, the miner was upset because they had been required to switch mobile equipment, and they said that that was a discrimination, or that they were not selected to work on the crew that was going to work when they did a temporary shutdown of the operation. And at another point, the individual said that they were interrupted by a member of management when he was attempting to discuss a safety concern with the inspector. But nonetheless, this came back that it was not a form of interference or discrimination. And there's a lot more that goes into them, obviously. We did a pretty quick run through of these cases, but nonetheless, interference cases, discrimination cases, those continue to get a lot of attention. We saw a big spike in the really the prosecution of interference and discrimination claims during the Obama administration, and that's not just with MSHA, but for whistleblower statutes across government agencies and administrations. And they continue to be taken pretty aggressively. So if you ever find yourself in a position that there is a claim of discrimination or interference, there will be a very or relatively invasive investigation done by MSHA. These take potential or priority, I should say, over any kind of agent investigation or really anything other than a serious injury or an accident investigation. They will be done by one of MSHA's special investigators. They should be taken very seriously because the potential ramifications can be pretty hard felt by an operator and the miners at the facility. So with that, we have one last case, and I'll put this one in here just because it's the conclusion to what has been a very long and drawn-out case, but with Sunbelt Rentals. And this has to do with workplace exams. As you can see up top, the docket number is from 2013, which is when the citation was issued. It went through multiple appeals and administrative law judge and commission hearings. What came down from it is a rather far-reaching implication that there is an inherent adequacy requirement when you're completing a workplace exam, that this adequacy requirement is determined by the reasonably prudent minor test, meaning is what you did or what the person performing the workplace exam did what another reasonably prudent minor would have done in the same circumstance. The question also looked at what was the definition and how expansive was the definition working place. In this particular case, it looked at how high up in a vertical structure where work was taking place did they miners or the contractor specifically has to perform their workplace exam. So it looks at when you are working in an area, you have to look beyond just what is immediately around you. And in this case, you have to look a little beyond the exact area where you're working to those areas which, if something occurred, it could affect you. In this case, a piece of material fell off of a preheat tower above where miners were working and struck a miner. They determined that that area above where people were working was part of the working place, and therefore should have been inspected as part of the workplace exam, because if the material fell, it could directly impact those working below it. This can be, not just in vertical working areas, but it can be something that is applied to if you have, a pit or an extraction area, and there could be a release of water above it or something along those lines. So it did enlarge what we have to consider for working areas. We need to make sure that if we're doing a workplace exam, we're looking beyond what is immediately around where the individuals are working and where they could be impacted by a change in the environment or a change in circumstances in another area. With that, I try to keep us as close to an hour as possible. I just want to tell everyone again, if you do have questions about COVID-19 and what resources there are for you out there, I welcome you to look at the materials that we put up on our website. We have a dedicated page now, which outlines a lot of frequently asked questions that we've been getting, also a lot of best practices, or just reach out directly to me. Also, as I said before, we're going to continue to update the MSHA Defense Report, both with MSHA-specific topics, as well as anything that comes up of interest that is going to really benefit or impact the mining industry from the COVID-19 perspective. So with that, don't forget to sign up for the notifications or watch that out. Lastly, the final two webinars of 2020, which is crazy to say, we're already looking at the final two, are going to be in September on the 22nd, as well as December 12th. Welcome you all to join us again for those. And, I say this, and I do take it into consideration when you guys give suggestions, but if you have something that you think would be beneficial or you would like to hear for the 2021 series, please let me know, and we'll definitely take that into consideration when we're putting together the schedule. So with that, I welcome any questions through the chat function, as we talked about earlier, or, always you can feel free to reach out to me directly, and I'd be happy to get on the phone or exchange a couple emails and discuss any situation you might want to. I see one question that has come in, and that is, how has the blur impacted EFS, or education field services? So the agency has actually put some renewed effort into getting an EFS person for each state. This individual should be able to help you, and if you don't have one specifically for your state, they have been making those resources available from neighboring states. So I would say it's been less impacted by the blur and more from your state-to-state area. So I will say that the EFS program, it was starting to get pretty thin. There have been a few people made or put into EFS roles recently. So if you don't know who that is and you want those resources, I would reach out to your local field office, because there's typically at least one per state, or that is the intent. If it's going to be coal or metal, non-metal, the person who is in the EFS typically has experience in the specific industry that they are being offered to as support. So that hasn't really been impacted too greatly by the blur. It's more so just been impacted by the number of people maybe who have retired from the agency who are in those roles, or just other general staffing implications. All right, and that looks like all the questions we have for today. So I want to thank everybody for joining us, and have a very good rest of the week and a safe week. And we will talk to you in September when we have our next webinar. Thank you again.